Good afternoon and good morning, ladies and gentlemen of the audience. Welcome to our NSL seminars. My name is Hualing Fu, Dean of the Faculty of Law at the University of Hong Kong. Thank you for joining us in this Saturday afternoon and our morning. Today we're going to talk about the NSL in international law context. There's no doubt that legally speaking, the NSL has two dimensions. The first is the domestic law or constitutional law dimension. The NSL is made in accordance with the Chinese Constitution, the Basic Law, the May 28 decision of the NPC, and NSL then has been implemented in Hong Kong, interfacing with local legislation. There's a clear legislative hierarchy with the Chinese constitutional law at the top of the order. That's the primary dimension. There's a second and secondary dimension, that is the international law dimension to the NSL. That dimension is clearly, decisively, and quite forcefully acknowledged by Article 4 of the NSL and, of course, Article 39 of the Basic Law. There's the Joint Declaration followed by the Basic Law with Article 159 of the Basic Law specifically anchoring the Basic Law at the Joint Declaration. And so as a result, the NSL has to be assessed from an international law perspective. So how meaningful that exercise will be? So today we have three distinguished panelists to discuss the international law dimension of the law, including the international law validity and the legitimacy of some of the international reactions to the legislation. We have three speakers today. Our first speaker is Professor C.L. Lim. Professor Lim is Choh-Ming Lee Professor of Law at the Chinese University of Hong Kong. He is Honorary Senior Fellow of the British Institute of International and Comparative Law, Visiting Professor at King's College London. I'm proud to say that Professor Lim is a former colleague. He was a professor of law here at HKU before he crossed the harbor to join the Chinese University. Our second speaker is Professor Albert Chen. Albert is Chen 9-year professor in constitutional law at the HKU Faculty of Law. He is also a member of the Hong Kong Basic Law Committee of the NPC Standing Committee. The third speaker is Professor Tony Carty. Professor Carty is a professor in Beijing Institute of Technology School of Law. Again, he was our YK Pao professor in public law. So today we have a very nice reunion of our former colleagues. So without further ado, may I invite Professor Lim to make his presentation. The floor is yours.
Thanks very much, Hualing. Thank you very much to Hualing, the Dean, and to Hong Kong U for this most kind invitation. And it's very good to see my old colleagues, Albert and Tony. What I'm going to do is to say something first about the Joint Declaration, and then I'll get to the conflicting claims we've heard between the United Kingdom and the People's Republic of China in recent weeks and in recent months. And then I'll say something about the national security law. I won't read from a text because some of the points are quite technical. And so I'm going to try and simplify them a little bit and to hopefully pick them up during the Q&A. I have two broad points to get across so that you have a sense of where I'm going. The Joint Declaration allows the two parties, the United Kingdom and the People's Republic of China, to conclude as they wish as to whether there has been or not a breach of the treaty. Some people may think that this is not such a good idea, that there should be an arbitration clause, for example. I'm not so sure. I tend to think that it is always better in these kinds of situations that if parties ever wanted to, and this is probably highly unlikely, ever wanted to arbitrate any point at all, they should go hand in hand and to do so by way of a special agreement. It makes less sense to me to have an arbitration clause in a treaty where one party invokes that arbitration clause and the other party says that the tribunal has no jurisdiction. And we've seen that before. And that won't necessarily improve the relationship between the two parties if one party feels compelled to go to arbitration. So the situation we have is a joint declaration whereby if one party feels that there has been a breach, it's up to them. It's up to that party to conclude what that breach consists of. And that more or less is where we're at with the joint declaration currently. Talk of a treaty breach is a 5-year-old story. The first public statement from the United Kingdom about a treaty breach was, I think, about 5 years ago. And at the moment, all eyes are on the situation that has followed from the passage of the national security law. Now, as far as my understanding of the position of the People's Republic of China is concerned, the Joint Declaration is a fully executed treaty. It is completely executed. It is fully performed in the same way that an artifact loaned by one country to another, when that artifact is returned, then the treaty governing the loan of that artifact is fully performed. Likewise, if a treaty has been concluded concerning the cession of territory, once that territory has been ceded, the treaty has been fully performed. And you can see that line of thinking in the position of the People's Republic of China, as I understand it. But quite apart from that, there is also a point of construction. I have seen a statement from the PRC, and I think other people may have seen it too, where the argument is that what many people point to as the substance of the Joint Declaration really consists of an annex, the first annex in the Joint Declaration. The Joint Declaration consists only of 8 paragraphs. It's a very thin document, but it has 3 annexes together with an exchange of memoranda between the two parties. And the argument from statements I've seen is that much of what we take to be the substance or the content of the Joint Declaration is contained in the first annex. However, that first annex is an elaboration of the basic policies of the People's Republic of China in relation to the Hong Kong Special Administrative Region. So the argument on the part of the People's Republic of China is that this is merely the PRC's own elaboration of its policies. So there is a point of treaty construction there. This position, this argument is not without support if we look at the negotiating history of the Joint Declaration. From the outset, As I understand it, the PRC's position was that 2 years would be given to the negotiations, and even if the negotiations were unsuccessful, the People's Republic of China will unilaterally state its position on the recovery of Hong Kong. To me, some of the most important aspects of those negotiations occurred during the months of July and August of 1983, between the second and third rounds of negotiation. At that juncture, the PRC delegation made a public statement about the indivisibility of sovereignty, Chinese sovereignty, and the continued administration of Hong Kong. This, of course, was not the United Kingdom's position. The United Kingdom's position was that the 19th century treaties concerning Hong Kong Island and Kowloon did lawfully cede these territories to the United Kingdom. But notice here the positions of both countries. You have a situation that is quite unlike the situation we've seen with, for example, newly decolonized nations in Asia and Africa, where you have a colonial unit emerge from the chrysalis of its colonial administrative boundaries to become a new independent decolonized nation. There was no question here, not only because formally Hong Kong had been removed from the list of non-self-governing territories kept by the Decolonization Committee at the United Nations, although that is a very important fact that Hong Kong was not treated as a non-self-governing territory, but also because Hong Kong was acquired as a result of a war between two sovereign nations. And so from the Chinese viewpoint, the proper remedy was the recovery of Hong Kong. And in the post-war period, after the Second World War, there was talk of that. And this goes back to the American president, to Franklin Roosevelt, who sought to prevail upon the United Kingdom to return Hong Kong, but was resisted. All of this I mentioned because I mention now because it is important to understand the kinds of statements that we're seeing from the People's Republic of China. So, for example, in July of this year, the Chinese ambassador to the United Kingdom said, if you allow me to quote, "The United Kingdom side knows well that Hong Kong is no longer under its colonial rule." And you might wonder, why are we reciting all this? I continue to quote the Chinese ambassador, "and that Hong Kong has returned to China and is now part of China. The UK has no sovereignty, jurisdiction, or right of supervision over Hong Kong after the handover. However, the United Kingdom government keeps making irresponsible remarks on Hong Kong affairs through its so-called 6-monthly report on Hong Kong," end quote. This statement employs what appears to me to be a careful, deliberate legal formula. And it goes back to a debate during the negotiations leading up to the Joint Declaration, where there was talk of the United Kingdom maintaining administration over Hong Kong, even despite conceding on sovereignty. So there was raised, the issue was raised during the negotiations about whether the United Kingdom might continue to administer Hong Kong anyway, even if it were to concede that China has, and from China's point of view, always has had sovereignty over Hong Kong. Some of that was reflected in things that happened at Hong Kong University. Albert, my friend Albert's former teacher, Peter Wesley Smith, for example, wrote in 2 of his books that there was this possibility, if only the United Kingdom would consider it, of continued administration. And the argument went something like this, and he was citing Anthony Dick's writing in the China Quarterly in 1983. If China has always argued that the 19th century treaties were unequal treaties and that they were therefore invalid, why doesn't the United Kingdom simply accept that and say, all right, fine. So none of these treaties were valid, and we accept your argument that these were unequal treaties. The effect would have been that there would no longer be the question of the culmination of the lease over the new territories. There's no end date to the lease if there never was a treaty. Now, this slightly complex argument would also involve, of course, the United Kingdom conceding that China is sovereign over Hong Kong and over Kowloon. That there then arises, of course, as a result of this question of how the United Kingdom might have the authority to cede overseas territories. But that was an internal legal question for the United Kingdom. How does Her Majesty cede overseas territories? But part of this argument, the essential part of this argument, was that despite doing so, the United Kingdom would nonetheless simply continue to administer Hong Kong. So fine, the previous treaties were unequal and, as you say, and invalid, but we're just going to continue to administer Hong Kong. By what authority would the United Kingdom administer Hong Kong? This too was, to Peter Wesley Smith and to Anthony Dix, an internal legal question, and they both had answers to these questions. Wesley Smith wrote, however, that it comes too late in the negotiations by 1983. And you could say the simple response is it did come too late, or an even simpler response would have been that the United Kingdom was given 2 years. Treaty or no treaty, China would have stated its own position about the recovery of Hong Kong. So that's the background to the Joint Declaration. I come now to recent conflicting statements before moving on to the national security law. In relation to conflicting statements that we find now over what the Joint Declaration means, I think lawyers in the audience will remember Lord Atkin quoting Humpty Dumpty, "When I use a word, it means just what I choose it to mean." And we recall Alice's response to that in Through the Looking Glass, The question is, which is to be master? And here we have a situation where conflicting claims are being advanced, and each side asserts mastery over the Joint Declaration. The exchange of claims recently on the Joint Declaration is exactly like that. We have a document which is also in 2 languages, where both languages are equally authentic. And in fact, the Joint Declaration started out as a Chinese proposal that there should be 2 separate declarations, not 1. And that DNA shows in the treaty when we read it in the first 2 paragraphs of the Joint Declaration. They appear like separate declarations brought together and packaged as a treaty. Let me put it even more bluntly. This was a disagreement that was reduced to writing, wrapped in the form of a treaty. I mean, to emphasize, 1 treaty. But essentially, you have 2 sides stating their own separate positions. Now, the linguistic aspect and the structural aspect, the fact that this thing has 2 languages and in fact are 2 creatures sewn into one, leads me to suspect that it is not as simple as it might seem to say there is a clear breach of the treaty. I'm not saying that these are the reasons that we have for simply concluding that there can never be a clear breach, but it certainly weighed on my mind, these linguistic and structural aspects, in an article that's coming out in the Law Quarterly Review in January, where I say that I don't think, whatever it is, you can say that anything about the Joint Declaration is clear. And so I'm doubtful about whether you can say, whether there has been a breach or not, that there has been a clear breach. All of that is in a forthcoming article, which I won't repeat here, so as not to preempt myself and to bore you. Why then say it? I'm referring to British statements currently that there has been a clear breach of the Joint Declaration. There are echoes here of an event, an incident in 1982 when the then British Prime Minister was returning from Beijing to London, and en route she gave a speech in Hong Kong where she talked about how China must live up to its responsibilities as a major power and must abide by its treaties. There is a book by Cottrell where he quotes a British official who was present on that evening, saying that he thought that that additional remark was superfluous, that what Margaret Thatcher should simply have said was, we think that these 19th century treaties are valid. We see something similar today because in June, the British Prime Minister, Mr. Johnson, wrote a letter in the press where he said roughly the same thing, that China as a major power should live up to its responsibilities. I think when you say something like that, you cannot then go back. And so that leads you to say subsequently, well, there you go. China has not done what I've suggested, and there lies a clear breach. So let me summarize this part about the exchange of claims between the United Kingdom and the People's Republic of China in recent weeks and months. This is a joint declaration. There are 2 declarations. That's what the title of the treaty suggests, although we cannot put too much weight on that. But the truth is that the United Kingdom knew that the People's Republic of China would have stated its own position regardless of the negotiations. The British instinct was to therefore tutor the Chinese side on how Hong Kong is run. And it is so complex, by the time the tutorial is over, the hope was that the PRC would see things the way the United Kingdom saw things, that there was no way the People's Republic of China could administer Hong Kong. The Chinese approach was, say what you will, but by then it won't matter. Once Hong Kong is recovered by China. And no doubt it was also important to get out with dignity intact. But it has led to two popular assumptions. And I think the two popular assumptions are, firstly, that you have a treaty called the Sino-British Joint Declaration, which has something to say on just about everything for 50 years. And that these consist almost wholly, in fact, if not wholly, of China's binding obligations to the United Kingdom. That this is a treaty which will last for 50 years, imposing obligations on one side. And that should alert us that if so, this must be quite a remarkable treaty. The second popular assumption is that there are international treaty rights at work. I believe that both these popular assumptions remain open questions at best. What the Joint Declaration itself says is that the provisions, and I emphasize the word provisions, the provisions of the International Covenant on Civil and Political Rights shall continue to be applied. And most people interpret that to mean that the ICCPR as a treaty continues to apply. But note the words "the provisions of." I will come back to them. These words are found in Article 13 of the first annex in the Joint Declaration, but Article 13 also refers to such rights as provided for by the laws previously in force. What rights were protected in 1984? The International Covenant on Civil and Political Rights was not Hong Kong law. The only rights that were protected were common law rights. Likewise, if you go to the main body of the Joint Declaration in paragraph 3, subparagraph E, you find in two places reference to rights being ensured by, and in the second place, being protected by law. And what would law have meant in 1984? Not international treaty rights, but common law rights, because these treaty rights had not been incorporated, at least at that juncture. But that was 1984, which brings me now to my comments on the national security law. What Britain sought to do was to repair the situation by incorporating the International Covenant on Civil and Political Rights into Hong Kong law. But the United Kingdom sought to do so after 1984, after the Joint Declaration had been signed. Essentially, the United Kingdom must have taken the view that the Joint Declaration was like a blank check. The previous system will remain in place, existing rights will remain in place, and that is said and signed in 1984, but then there would be 13 years to go before the actual handover date, and during those 13 years, the United Kingdom could simply fill in a blank check and that the reference to the preservation of the existing system should be a reference to 1997. The enactment of the Bill of Rights Ordinance incorporating the International Covenant in 1991 was something like that. What is truly remarkable is that Article 4 of the national security law itself continues to employ that same formulation in seeking to preserve our existing rights. That, on the face of it, on any reading, is what Article 4, which my friend Hualing had referred to earlier, which Article 4 of the national security law says, and if I may, can I just read it to you? The rights and freedoms, including the freedoms of speech, of the press, of publication, of association, of assembly, of procession, and of demonstration, which the residents of the region enjoy under the basic law of the Hong Kong Special Administrative Region, and the provisions of the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights, as applied to Hong Kong, shall be protected in accordance with the law. Now, some people don't believe that. Justice Spiegelman, we've seen, resigned, citing the content of the national security law. The chairman of the Foreign Affairs Committee in Parliament in the United Kingdom has expressed similar skepticism and called for British judges sitting on Hong Kong's Court of Final Appeal to pull out. But we have all, I think, or many of us, have paid great attention to Lord Reed's careful statement, and it has given us heart. That statement comes down to saying, let's wait and see. The heart of the controversy over the national security law, insofar as the Joint Declaration is concerned, to my mind, comes down to saying that Hong Kong's autonomy has been eroded. One response to that, we could say, is that autonomy has not been eroded if and insofar as this may be a foreign affairs matter under paragraph 3 of the Joint Declaration and Article 11 of the first annex. Mr. Raab, the Foreign Secretary, has cast doubt on this potential argument quite publicly, but he has not said what the precise response of the United Kingdom is to this point. However, if I were to imagine what this argument could be, and this is not the position of the United Kingdom, I'm just trying to imagine what the argument could be, you could say, well, it has been eroded, Hong Kong's autonomy has been eroded, because the matters covered by the national security law should fall within the police powers of the Hong Kong Special Administrative Region, and you could cite Article 12 of the first annex. There are two problems with this argument, if this indeed is the argument. The first is, as I've said, the annex, the status of the first annex has been called into question. The PRC's argument being that, as its title says, the annex is merely an elaboration of the PRC's basic policies towards the HKSAR. But the second, and I think perhaps even the stronger argument against the view that the NSL deals with matters that fall within Hong Kong's police powers, is that when you read Article 12 of the first annex carefully, the next sentence after the police powers sentence goes on to say, essentially, no troops. No troops. The Hong Kong police will deal with security matters, no troops. You could argue that that is all Article 12 on police powers means, no troops. So insofar as the Joint Declaration is concerned, we're really dealing not with very detailed treaty arguments, we're dealing with actual expectations. Actual expectations that are shaped by sometimes very emotive public statements. Since the 20th century, we've seen diplomacy become parliamentary in nature. People imagine that diplomacy is a little bit like having an argument in a legislature or in the United Nations General Assembly, that it is very public and very loud. And in the 2000s, what we found, or what the United States, for example, found, was that small nations can sometimes level the playing field by invoking international law or statements about international law in public against the United States. And I think the United States, the Bush administration then has cottoned on since that two can play the same game. Lawfare can be played from both ends. And the current controversy over the Joint Declaration strikes me as a kind of low-level lawfare, simply making statements about what we presume treaties to mean. The question I would ask is whether, say, the United States, which has taken a very active role in seeking, as it claims, to preserve Hong Kong's position, is the United States benchmarking some of those claims, some of those assertions against specific terms in the Joint Declaration at all? And the answer could be no. When the United States refers to the violation of rights, is it referring to how rights are provided for under the Joint Declaration or its own conception of rights? When it comes to clear breach, when the Foreign Secretary, Mr. Hammond, 5 years ago, spoke for the first time that the United Kingdom has spoken of a possible treaty breach, when he spoke of a treaty breach, he said that there has been a serious breach. Now, when someone says there has been a serious breach of a treaty, you sit up and you listen. But when someone says there has been a clear breach, a clear and serious breach, that is the formulation that is being used, that has been used by Mr. Johnson and Mr. Raab. I'm not sure that by adding the word clear, that it helps to make the argument stronger. Perhaps what we are seeing is the deterioration or the deteriorating state of international law. I'm sure Tony, Professor Carty, has much to say about that. I grew up reading Tony Carty, talking along those lines, that whenever people now speak of a treaty breach, it is as meaningless to those saying it as for those hearing it. So I come now finally to the Chinese response. Yesterday, the spokesperson, Zhao Lijian at the Chinese Foreign Ministry said, if I can quote, "As the British side broke its own promises, the Chinese government will consider not recognizing the British national's overseas passport as a valid travel document and reserve the right to impose further measures." What does this mean, quite apart from what it might mean for those who hold BNO passports? This is an invocation of international law. This is a very precise, very careful invocation of international law, an invocation of Article 23 of the Articles on the Responsibility of States for Internationally Wrongful Acts, a document produced by the International Law Commission, which means to state the position under customary international law. Now, I'm going to stop talking like this and I'm going to try and put it in plain terms. If you think someone has violated your treaty rights and there is no arbitration clause, you can respond. You can even respond under Article 23 with an act which otherwise would be unlawful. But this is not something which I've noticed. This is not something that has yet happened. Both the United Kingdom and the People's Republic of China have reacted, or a particular party is talking about reacting, and not with a measure that otherwise would be unlawful, but with apparently lawful measures, even if the other party disagrees. What are we talking about here? We're talking about the United Kingdom terminating its extradition treaty with Hong Kong. We're talking about issuing visas. We're talking about China not recognizing BNO passports. My point is that things, notwithstanding the absence of an arbitration clause, are still being kept within manageable bounds. This goes back to my point that it is not always helpful to have an arbitration clause, provided, and it is conditional, provided that the parties are better able to manage the situation without any third-party intervention, including third-party dispute settlement. And besides, I think over time, especially in the last few weeks and months, we've been able to narrow down some of the issues when we look at what's happening and we look at the Joint Declaration. And that is where we're at as far as the Sino-British treaty relationship is concerned. I don't know, and I won't say about anything about other positions, such as the United States position, because I don't want to preempt Professor Anthony Carty, and I don't want to say much more about the national security law, because no doubt Albert is in a much better position to speak authoritatively on that issue. So thank you very much. I better stop here. Thank you.
Thank you very much for this very well structured and clear presentation. And like what your characterization of the Joint Declaration as a disagreement reduced to writing wrapped in the form of a treaty. We'll come back to that probably. So now may I ask Albert to make his presentation, Albert?
Okay, thank you, Hualing. I'm pleased to hear Chen Ling speaking in detail about the international law aspects of this matter, and also the nature of the Joint Declaration and what exactly it involves, and whether it creates particular obligations which may be said to have been breached now. So what I'll do is to look at this matter from the perspective of the national security law. In particular, I would like to discuss whether the enactment of the national security law and the content of the national security law may be regarded as a breach of the provisions of the Joint Declaration, assuming that it is relevant to discuss this question of the alleged breach of the Joint Declaration. So, so first, let's clarify the legal basis for the enactment of the national security law of the Hong Kong SAR. This law, as we all know, was enacted by the NPC Standing Committee and inserted into Annex 3 of the Basic Law in accordance with Article 18 of the Basic Law. And so we go back to Article 18 to see what it says. Basically, Article 18 is about the application to Hong Kong of mainland Chinese laws, or what is called in Article 18 national laws. Chen Ling just referred to Professor Peter Wesley Smith, my former teacher here, at Hong Kong U Law School. And when we were law students here in 1970s, we learned a lot about the application of English law to Hong Kong. So acts of parliament that could be applied to Hong Kong, either by express provision or by necessary implication. So the counterpart in the post-97 regime for the application of the law enacted outside Hong Kong to Hong Kong itself is Article 18. So Article 18 provides a channel and a procedure for national laws made by the Chinese legislative authorities to be applied to Hong Kong. And Article 18 limits the application of such national laws to laws that relate to defense and foreign affairs and other matters outside the limits of the autonomy of the Hong Kong SAR as specified by this law. So one of the controversial issues that arose when the NSL was enacted was whether it concerns a matter outside the limits of the autonomy of the Hong Kong SAR. If so, then it would not be consistent with Article 18. Well, that brings us to Article 23 of the Basic Law, which says that the Hong Kong SAR shall enact laws on its own to prohibit treason, secession, sedition, subversion, etc. So basically, on matters of national security, as listed in Article 23, the Hong Kong SAR has a constitutional obligation to enact laws to protect China's national security. The Chinese version of Article 23 makes it clear that this matter of legislating on national security is not only a power enjoyed by the Hong Kong SAR, but also an obligation or responsibility. So the Hong Kong SAR government and the Chinese government has always said, not just now, but since 1997, that it is the constitutional obligation or duty of the Hong Kong SAR to enact laws under Article 23. So as I understand the situation, the legal basis for the enactment of the NSL is that since Hong Kong has failed to perform its constitutional obligation under Article 23 for 23 years after the handover, and is not in a position to perform such obligation in the foreseeable future. And given that threats to national security have already materialized as demonstrated by the riots in the anti-extradition movement of last year. Therefore, it is justified, according to this view, for China to invoke its power under Article 18 to enact a national security law for Hong Kong. So I agree with the view that that the enactment of an NSL under the present circumstances under Article 18 is consistent with the Basic Law. The Basic Law imposes a constitutional obligation on Hong Kong SAR to enact these laws, and Hong Kong SAR has failed to perform the obligation within a reasonable time after the handover. So since national security laws are supposed to protect the interests of the central government, it is legitimate and justified for the central government to step in to enact the laws which the Hong Kong SAR has failed to enact under Article 23. So I believe that the power to enact laws on national security under the Basic Law is not the exclusive power of the Hong Kong SAR under Article 23. It is a concurrent power, and as we all know, concurrent powers exist in other jurisdictions in which there is a division or allocation of power between the national authorities and the local or provincial or autonomous authorities. So concurrent power is a power which can be exercised either by the local authority or by the national authority. So I think it is clear as a matter of the Basic Law and constitutional law that But in these circumstances, the central authorities have the power to enact national security law under Article 18, and such a national security law falls within what is mentioned, what is described in Article 18 as a law on matters outside the limits of the autonomy of the region. I think it can be generally agreed that for states in the world today, that legislation on national security is always a matter outside the limits, outside the autonomy of any particular autonomous region within a state. I think this should not be controversial. So now what about the Joint Declaration? The point which I'm going to make is that the Joint Declaration has not made any provisions, either in its text or in Annex 1 or other annexes, about the possible application of national laws to the Hong Kong SAR. The Joint Declaration and also the Basic Law has got provisions to preserve the existing laws of Hong Kong, the existing common law and the existing legislation, the existing common law system. It also authorizes the Hong Kong SAR legislature to make laws. But it doesn't say anything about the application of national laws to Hong Kong. But in the course of the drafting of the Basic Law in the 1980s, it was pointed out by the Chinese draftsman that there must be some kind of provision or mechanism for the application of some mainland laws to Hong Kong. Now, my colleague, Dr. Michael Ng, and I have recently done some research into the history of the drafting of the Basic Law and the negotiation behind the scenes between the British government and the Chinese government on provisions of the Basic Law. So even though formally speaking, Britain didn't have a role to play in the drafting of the Basic Law, informally, Britain did convey many comments and views to the Chinese authorities on particular provisions of the draft Basic Law in the course of the drafting. And the information about such communication between the Chinese British governments have now been released in the British National Archive. So Dr. Ng, Michael Ng, actually retrieved some of these documents. And also, I'm also grateful to Mr. Gary Zheng of the South China Morning Post, who also obtained further information by relying on the right to call for information. So further information has been released also, and the material is originally in the British National Archive. So basically, since I don't have time to go into details, basically the point which I want to make is that there is very clear evidence that the British side in the process of the drafting of the Basic Law has not voiced any objection to Article 18, what subsequently became Article 18 of the Basic Law. In particular, British side has not raised any objection to the provision about the possible application of national laws to Hong Kong on matters of foreign affairs, defense, and matters outside the limits of the autonomy of the Hong Kong SAR. For example, there's a letter which we retrieved from the Foreign and Commonwealth Office to the Prime Minister's office, dated 17th of February 1989, with an annex. And the annex lists out all the improvements to the first draft of the Basic Law, which can be seen in the second draft of the Basic Law as of January 1989. And the letter stated that the British influence on the drafting process had been extensive and important. The Chinese side has made it clear that they valued the British contribution and has accepted many of our ideas, that is the British ideas. Our assessment of the position now is that all the provisions of the Joint Declaration are reflected in this second draft of the Basic Law. And if you look at Annex 2 and also the subsequent information obtained by Mr. Gary Cheng, you can see that the British side actually did not propose any changes or did not voice any objection to the provision in Article 18 about the application of national laws to Hong Kong on matters of defense, foreign affairs, and matters outside Hong Kong's autonomy. So my point is that insofar as the national security law has now been enacted under Article 18, and insofar as Britain has not indicated any objection to Article 18 of the Basic Law as being contrary to the Joint Declaration. So I think it can be concluded that so long as the enactment of the national security law is consistent with Article 18, the mere act of enactment of the law cannot be regarded as a breach of the Joint Declaration. So then it brings us to the second question. Even if the act of enacting the national security law is not a breach of the Joint Declaration, what about the exact content of the law? Are there provisions in the NSL which restrict rights and freedoms in such a way that are contrary to the Joint Declaration, or infringes upon Hong Kong's autonomy in such a way that it is contrary to Hong Kong, to the Joint Declaration? So I think that, or at least my own view is that we cannot say, it is difficult to say or to come to the conclusion that it is so clear that the national security law has restricted rights and freedoms in Hong Kong in such a manner that it is clearly contrary to the Joint Declaration. Nor can it be said that Hong Kong's autonomy has been drastically reduced in such a way that it is contrary to the Joint Declaration. What the national security law has done is to create some new institutions like a committee on national security chaired by the chief executive, and a national security office established by the central authorities in Hong Kong. So these are the two new institutions. But I think cannot be said that Hong Kong's autonomy has been severely affected. Hong Kong still, has autonomy over all the matters provided for in the Basic Law and in the Joint Declaration, except maybe except in relation to certain cases, which I will come to in a minute. So what about infringement on rights and freedom? So we look at the 4 sets of criminal offenses created by the national security law. Can we say that these criminal law provisions are an infringement of rights and freedoms that is inconsistent with the Joint Declaration? Well, we all know that rights and freedoms can be subject to restrictions in the interest of national security and so on, provided that the restrictions are proportionate. So you look at the 4 sets of offenses. Take the terrorism offenses. The terrorism offenses in the national security law, and the definition of terrorism is actually consistent with Hong Kong's existing law and also the international law or the international law understanding of terrorism. So that's one of the 4 sets of offenses. Now take subversion and also secession. There are criminal offenses now created relating to trying to achieve Hong Kong's independence, or overthrowing the central government or the Hong Kong SAR government. But similar laws on subversion exist in almost every country to prevent overthrowing of the government. And as far as secession is concerned, this is a very important matter from the point of view of the Chinese government. The whole purpose of the Joint Declaration was to recover Hong Kong sovereignty, as Chen has already pointed out. So it is at least arguable that that laws to restrict activities aimed at secession or independence of Hong Kong are acceptable or legitimate restrictions on relevant rights and freedoms. So then we come to collusion, okay, or collusion with foreign forces to endanger national security. You look at the provisions of the law on collusion, and maybe since the law on collusion is particularly complicated, I will actually refer to the text. It is in collusion is Article 29. Okay. Actually, my colleague Simon Young and I have recently published an article on one aspect of Article 29. The article is very complicated, but basically, collusion includes collusion with foreign forces for the purpose of waging war against the PRC and imposing sanctions or blockade against the PRC and so on. So why is there such a provision of collusion with foreign forces to impose sanctions on Hong Kong? That's because last year, during the anti-extradition movement, there were people in Hong Kong, including politicians who went to the US to lobby for laws which will be used to impose sanctions on Hong Kong. And as we all know, those laws had subsequently been passed and sanctions had now been imposed. So that is the mischief which this article, this aspect of the article was aimed at. Now, it has been said that, well, the law on subversion is too broad and vague, but because it covers even acts against the SAR government. But let me give you an example of one key provision in the law on succession, law of subversion. Subversion includes attacking or damaging the premises and facilities used by the Hong Kong SAR body of power, so as rendering it incapable of performing its normal duties and functions. So why is that this provision? That's because on July the 1st last year, as we all know, people broke into the Legislative Council and destroyed most of the facilities there, so that the whole of the electrical had to be repaired. It could not meet for several months. So this is what the provision, what this aspect of the provision in Article 22 is aimed at. So aimed at preventing. Okay, so my point is that the restrictions on rights and freedoms imposed by the national security law can be perceived as legitimate in the circumstances of Hong Kong, and also, many of the other provisions, many of these provisions are actually consistent with national security law elsewhere, and also the terrorism or counterterrorism law elsewhere. So finally, I turn to probably the most controversial aspect of the national security law, this provision about the National Security Office established by the central authorities in Hong Kong, having power to exercise jurisdiction in relation to three kinds of cases. Okay, so it is arguable that the exercise of jurisdiction directly by the central authorities in these three kinds of cases may be said to be inconsistent with Hong Kong's autonomy or Hong Kong's judicial power. So my own view, I think as Chen has said, we have to look at how these provisions are actually implemented in practice. Okay, so if these provisions are almost never used, then I don't think that it can be said to be an infringement of Hong Kong's autonomy. If these provisions are frequently used, okay, used every month, every week, then of course, it would be considered an infringement of Hong Kong's autonomy. So what actually are these provisions aimed at? I would suggest, as the speech made by the Chinese official introducing the draft NSL to the NPCSC indicated, these provisions are aimed at situations similar to emergency situations referred to in Article 18 of the Basic Law. And in Article 18 of the Basic Law, which contains an emergency provision, was actually referred by the Chinese official in charge of this bill when he presented it to the NPCSC. So as I understand it, these provisions about the National Security Office exercising jurisdiction over particular types of cases in Hong Kong are aimed at situations similar to emergency situations. For example, Article 55(2) says we have a serious situation in Hong Kong so that the Hong Kong government is unable effectively to enforce the national security law. Or, subparagraph 3, a major and imminent threat to national security has occurred. So I would suggest that these are actually situations akin to emergencies. And so Article 55, insofar as it confers jurisdiction on the National Security Office, should be regarded as a kind of emergency and residual power of the central authorities over Hong Kong. So I think, let me see how many minutes I've used up. Also, used up more than 20 minutes. So maybe that's all I want to say at this stage. I welcome comments and the discussion.
Right. Thank you very much. Now we move to the third speaker, Professor Tony Carty.
Thank you very much, Hualing, and it's a pleasure to be together with my former colleagues in Hong Kong U, Chen Lim and Albert Chen. I propose to talk about the international law the general international law to do with the principle of non-intervention in the internal affairs of countries. And I intend to do so in a general technical way rather than discussing in detail particular instances of intervention and non-intervention, which I think have been covered already very succinctly by Chen Lim Leng. Now, it is very clear that there is well, I could say it very generally to begin with, though I don't want to talk too much about the actual political situation. There is very much a view expressed quite strongly in the United States and then even in the last few days in the United Kingdom that Hong Kong is under attack in a new Cold War, and that it is a city that has to be defended if the West is to be defended against Chinese expansion and so on and so forth. The temperature is very, very high in the international community, though the distraction of the coronavirus maybe confuses the picture. But we have also the fear of China, its technological power, the campaign against Huawei, and the general anxieties about Chinese conduct in Xinjiang province and so on. The international environment at the moment is very, very charged. And that is a background context, but I want to talk more about the international law on intervention, and we'll come back to that context maybe later. It is very clear that there is a general consensus, and I'm reading from a text here, known to be grounded in customary international law, that no state may interfere in any way whatsoever in the internal affairs of another country, so as to undermine its political, economic, or social order. And this position is clearly stated and unanimously accepted in United Nations General Assembly resolutions, passed in 1965 and in 1970. However, the disregard at the present time of these, the disregard of these resolutions at the present time is so clear and so dangerous that it is necessary to look further to foundations for state conduct in a global inter-civilizational order, which goes beyond the ideas of statehood and sovereignty, to call for a mutual respect of the integrity and the diversity of peoples who together are called upon to share the future of humankind. The foundational principle of this essentially moral order is mutual respect. This is the starting point for the interpretation of detailed legal rules about non-intervention. The spirit of the conception and application of laws must be one which is free from expressions of contempt, of defamation, and of utter distrust. What the world is witnessing at the moment is a war of words, a vilifying discourse. In no small part, this is due to deep differences of understanding about appropriate forms of public discourse, particularly between the civilizations of East Asia, especially China, and the West, especially the United States. It is necessary to invoke urgently a dialogue of civilizations if one is to save the integrity of peoples. Now, the international law on non-intervention, General Assembly Resolution 2131 of the 20th session of 1965, the Declaration on the Inadmissibility of Intervention in the Domestic Affairs of States and the Protection of their Independence and Sovereignty, provides as follows, quite categorically: no state has the right to intervene directly or indirectly for any reason whatsoever in the internal or external affairs of any other country. And this resolution was passed unanimously. In 1970, another General Assembly resolution Declaration on Principles of International Law concerning Friendly Relations and Cooperation among States provides even more explicitly that armed intervention, and I quote, all other forms of interference in the form of providing financial or other assistance, or to incite or to tolerate subversive, terrorist or armed activities directed towards the violent overthrow of the regime of another country, or any interference in civil strife in another state, violates international law. These very clear propositions appear to be contested widely in Western legal doctrine, international law doctrine and state practice. The focus falls on another General Assembly Resolution 36/103 of December the 9th, 1981 on the inadmissibility of intervention and interference in the internal affairs of states. This went into much more detail still and is discussed by a private group of experts called the European Leadership Network, trying to devise common standards for non-interference between Russia and the West at present in Europe. This is a report of 2017. This European group of experts noticed that the provisions of the above 1981 resolution offer maximum clarity. It goes much further than calling for no threat or use of military economic coercion to require as well that states refrain from any action or attempt to destabilize a political system. The promotion, encouragement, or support, direct or indirect, of any action which seeks to disrupt the unity or undermine or subvert the political order of other states. And most important of all, any defamatory campaign, vilification, or hostile propaganda of one country against another. And finally, the exploitation and distortion of human rights issues as a means of interference. Now, the above mentioned European study recognizes the practicality of these formulations, but says that they largely boil down to descriptions of events, actions, and expressions of opinion, where there will be no agreed standards of objectivity between Russia and the West. The four standards enumerated have not been recognized universally as binding in general international customary law. And the Max Planck Encyclopedia of International Law entry on intervention by Philipp König, a German international lawyer who I would think is quite progressive and is known to Chen Lim, was more categorical in 2008. König says that this resolution is not helpful. Its broad definition was passed against the will of many states, by which he means Western states. In particular, he stresses that while hostile propaganda to influence the situation in another country is illegal, but only if one can prove that it was conducted by a former government and not by a formal government and not by private persons, nonetheless, in no circumstances, now this is really important, in no circumstances, says Koenig, is criticism of the internal politics of another state subversion if the criticism is substantiated by facts. This point brings one back to the difficulty mentioned in the European study above. There will be no agreement between Russia and the West as to what is meant by criticism substantiated by facts, especially in the febrile atmosphere at present, not just in Hong Kong, but generally in the US and in other Western countries in their attitudes towards China. There's been plenty of so-called social attitude studies that the hostility in the general public in Western countries, such as Britain, Germany, Finland, Australia, and so on, not to mention the United States, the hostility or the negative attitude towards China is up to about nearly 80% of the population. This has decisive implications for issues about the relationship between acts of subversion and foreign interference in the areas of freedom of speech, freedom of assembly, and academic freedom and cooperation beyond borders. Now, I want to try to go beyond this nitpicking about exact meaning of legal texts to point to what I think is the necessity to search for a moral foundation for international order among peoples. Some Chinese legal doctrine makes clear a connection between the rule of non-intervention of one state in the domestic affairs of another and the Bandung principles of international order formulated by the primarily by the Asian countries in the middle of the 1950s. There is a Chinese international lawyer, Choh-Ming, who is aware of the tendency of Western doctrine to wish to construct the rule of non-intervention, to confine it, constrict it, to overt forceful intervention. Instead, she argues that there is a broad prohibition of interference in each other's internal affairs. Traditional Western international law has to be understood as a legal ideology, that is to say, it is a weapon for criticizing others, while the Bandung principles reflect the needs of developing countries for respect in relations, mutual relations among countries. They represent an anti-hegemonic fight against the spirit of power politics. As for the Western attempts to restrict non-interference to a non-use of force, that is a separate rule covered by the international law on the use of force. Instead, intervention or interference has several forms, both forceful and non-forceful. An example of the former is humanitarian intervention with the excuse of protection of human rights, when in fact all disputes should be settled within the United Nations Charter. Non-interference, says Choh-Ming in her textbook on international law, which is not translated into English, covers any state or groups interfering in another state's internal or diplomatic affairs. No state should take any measures to force another state to accept a specific ideology, sociology, or political institution or intention. An example could be Secretary Pompeo asking former Tiananmen Square protesters what he could do to help democracy and human rights in China. This was in June 2020. Or saying recently, Pompeo saying that the world has tolerated too long the Chinese Communist Party government of China, whatever on earth he means by that. The range of internal affairs, according to Shao, includes any kind of subject matter and action within a state's affairs, such as politics, economics, society, military affairs, cultural, and diplomacy. The state employs agents to create panic in another state, funding anti-government activities, sending in spies, etc. All of this is interference in the domestic affairs of another country. Shao's is a perspective which is not simply based on grammatically parsing resolutions of the General Assembly. It is an expression of a widely held East Asian understanding of public discourse and interaction. It's deeply rooted in a Chinese philosophy that when dealing with interpersonal relations, harmonious silence is more advocated than critical debate. This is such a sharp contrast to the vitriol which is poured on China in government, press, and also academic opinion at the present time in the West. Mention is made of China's disregard of the basic law of Hong Kong and of international treaties without elaboration of the Chinese views about the implementation of the Joint Declaration and its undoubted competence to act under the basic law to make up for the Hong Kong failure to implement its obligations under Article 23 of the Basic Law. Very widespread Western and Hong Kong media comment, also Western and Hong Kong academic law comment, talks of the dangers of vague Chinese Communist Party understandings of concepts of subversion and sedition, without mentioning the long months of fierce militant violence by protesters on the streets of Hong Kong in the autumn of 2019, on a scale which it is beyond the usual province of civil police forces to be able to manage. It is not an uncommon academic research practice to call the application of double standards in debate and discussion of another country's conduct quite simply as racial abuse of that country. This is such a far cry from a Chinese cultural tradition which sees that a public discourse of an individual should be and will be born of rich emotion and of goodwill. In the classical tradition, going back to Liu Xie's study, The Literary Mind and the Carving of Dragons, written about 600 AD, with Confucianism as its core guidance, the author explains how good writers aim to express their own emotions rather than defend their own points of view, least of all to attack other views with whom they may not agree. Qualities Liu praises are emotion, courage, integrity, and creative talent. Each writer would be esteemed for their unique style generated from within their own life experience. In contrast, Western culture, represented in its most morally pure form by Aristotle in his great work Rhetoric, is a textbook designated to show how to persuade others efficiently and rationally. This course is not about bringing outward an expression of one's internal emotions, but one of directing rational argument to a particular audience which one is determined to persuade. Argument must be clearly directed to persons whom one understands impersonally, abstracting from one's own situation, although the intention is to attain one's own ends. In contrast, Liu describes a world where speakers are giving personal perceptions of the existing world, where their feelings and emotions dominate. Chinese culture uses literature and poetry to stress dignity and openness to empathy. In contrast, for Aristotle, an approach should not be too personal or emotional, but should be logical, rational, conceptually clear, and critical. A crucial consequence for public discourse and diplomacy is between the implicit and the explicit. Aesthetic implicitness is deeply rooted in Chinese culture. The beauty of the writing or the speaking inspires the reader or listener to understand what is hidden in the heart of the creative author. In contrast, for Aristotle, speeches must be reasonably arranged to convey meaning. The essential elements are clear propositions for acceptance and clear proofs to support them. Clear structure of argument is essential so that it is easy for the listener to understand what is being said and what is being wished. Again, in contrast to the style of Aristotle, Liu thinks the power of a discourse to inspire and move the hearts of the listener will rest upon its capacity to bring alive the most excellent aspects of a tradition, but never to challenge or argue about this tradition or to argue with the listener. At the same time, the discourse does have the general ambition to represent power and authority in an inspiring way and to encourage acceptance. It contains the flow and operation of political power, which influences the loyalties and belief of the people. In contrast, for Aristotle, the thinker should be original and individual in his ambition to persuade individual people. For Aristotle, discourse which understands and works with different forms of government is nevertheless not about pleasing those in power, but about persuading power in a particular direction. For the Chinese tradition, there is definitely a tendency to follow authority and to be scrutinized for political correctness, while for Aristotle, the main lesson is one of respect for facts and truth and ability to define argument in a reasonable, effective, and logical way. The outcome of the Chinese form of discourse is that it will usually communicate itself in expressive ways, allowing flexible and wide interpretations, but leaving great space for the audience to form their own understandings. Westerners will resist this in the Aristotelian tradition in favor of accurate, stable, precise rules which exclude possibilities of subjective, arbitrary understanding. The objective and the impersonal excludes the subjective and the personal. These ideal forms of discourse are not intended to represent as abstract models the actual mode of competing discourses between China, the US, and other Western countries at the present time. Although it is implied that other Asian and especially East Asian countries would probably tend, from their own tradition, to have some sympathy with China. Instead, the plea is that one might understand that even among the purest expressions of Western and Chinese discourse, there are simply huge possibilities of misunderstanding of what is proper diplomatic discourse, what is proper public communication, if indeed there is any prospect at all with the best will in the world for any immediate and quick communication. In other words, I think that what we have in the focus on Hong Kong as a Western city in a conflict between the West and China is that we have a conflict of civilizations where there is not really a mutual understanding about what is going on. One fundamental aspect of the Chinese tradition of discourse suggested by Liu is the central emphasis on the subjective, the respect for the space of the individual and therefore also of an individual community, and the care not to challenge one another and to maintain harmonious relations through silence, even if glaring deficiencies call for sharp criticism. That is what is to expect from China. But of course, the basic principle of the equality of civilizations means that it is not one which has to be accepted unconditionally by Western countries. The destiny of peoples is to share a common future of humankind means that they are all equally tasked to deepen mutual understanding of one another's different civilizations and to facilitate dialogue by encouraging the learning of their different thinking patterns and uses of language. This is definitely a long and painful process which could be cut off altogether by the tragical escalation of conflictual misunderstanding. So basically, I want to stress that in a similar way to Chen Lim's brilliant description of the history of the Joint Declaration, basic understanding of what non-intervention principle means in international law does not exist in international society. There are profoundly different concepts of intervention and non-intervention. And basically, Eastern civilizations understand non-intervention to include non-interference. It's a very broad concept which comes within the general remit of the concept of respect. But also the difference of civilization between China and the West, and between East Asia and the West, around the notion of what constitutes rational argument, what constitutes legitimate debate, and what, as Philip Koenig says, what constitutes fair criticism based on fact. All of these issues are profoundly contested. And what we have in the face of Hong Kong is virtually a kind of focal point of a clash of civilizations, which is very, very intense and very difficult for anyone in this context to understand. So I am not calling for either side of this civilizational conflict that it has to give way to the other side, but it has to recognize that there is an incommensurability about legitimacy of argument, legitimacy of discourse, and of normative standards that should apply. And so it is very much an appeal for mutual self-reflection and self-criticism and for calm in this very, very intense conflict, which, having spent 6 years in Hong Kong, I am aware at a personal and existential level how intense this conflict is and how much individual suffering and stress that it causes. So that's what I have to say. Thank you very much.
Thank you very much. So we have about 30 minutes for Q&A. So if you have, the audience have any questions, please use the Q&A function to send questions to all the panelists or a particular person. Be concise about the questions. So before we move to online, I just want to ask whether three of you have questions for each other.
No, none from me for now.
No, not for me. No.
Just one question for Chen Lin from me. I love your characterization of Joint Declaration as a disagreement reduced to writing. I mean, but then look at the current difficulties we are in. Would you say that they are rooted in the disagreement in the Joint Declaration? So we basically just inherited difficulties, and those questions have never been properly answered, and will not be properly answered. That's where we are now.
Yes, I think so. I think if you look at not just the treaty, but the background to the treaty, the negotiations. The negotiations nearly broke down because initially the United Kingdom would not concede on the issue of sovereignty, and it was Percy Craddock, who was the British ambassador to Beijing before, who drafted, I think it was a letter for the British Prime Minister to break the deadlock, and the formula was that Britain will concede on sovereignty if the outcome of the negotiations were acceptable to the people of Hong Kong. Now, the people of Hong Kong, as we all know, are very sophisticated people. Just because the United Kingdom states as its basic position that sovereignty will only be conceded if the outcome is acceptable to people in Hong Kong, doesn't guarantee, doesn't assure that there would be a very high degree of consultation, and did not, as far as I can see, ensure necessarily a very high quality or degree of consultation of the people in Hong Kong. But the people in Hong Kong are, being no doubt sophisticated, have no hesitation in holding the United Kingdom to its promise. It doesn't matter whether you mean it or not, we're going to hold you to it. And the United Kingdom, I suppose, not wanting to be outdone, plays along with that. There was also at the time, as far as I can see, this great need to assuage public opinion in the United Kingdom that this was going to be an honorable exit. You may not go so far as to say, if you were the United Kingdom, that people in Hong Kong are going to be in an even better position after the handover, but you're going to try and move in that direction to say Hong Kong is left more or less in the best possible position. And so today, when we have moments of public dissatisfaction, that's too weak a word, moments of public anguish in Hong Kong, I suppose Britain will feel that it can do no less but to assert what it considers to be treaty rights. I think that's fine insofar as a particular party feels that it has a reason to assert certain treaty claims, then it should just go ahead and do so. The problem arises when these claims are taken as settled conclusions on certain questions that the particular society is facing. So just because the United Kingdom says that your rights have been violated, doesn't mean that your rights have been violated or been violated as yet, or that your autonomy has been eroded, it doesn't mean necessarily that from a legal point of view, that autonomy has been eroded. No doubt there is room for confusion because many words that we use are also legal words. A treaty breach is a very technical term, but it is also in popular usage. So all of these things are traceable to the kinds of pressures that the parties faced, or in this case, the United Kingdom faced, in the negotiations leading up to the treaty and subsequently leading up to the handover. And Albert's already referred to the fact that although the United Kingdom played no part and could play no part in the drafting of the basic law, it could express its position through diplomatic channels. But now nobody is concerned about diplomatic channels as of this moment. It seems as if Britain's position is precisely what it claims its position to be very loudly. I don't know if that really answered your question,
Yes,
but the short answer is yes. I think so.
Thank you. Yeah, Tony, you have to mute yourself.
I think that Chen in his original presentation, and has now reiterated it, talks about a decline in the quality of international diplomacy, which takes the form of parliamentary diplomacy, where there are declarations about legality, but these declarations are never, to come back to Aristotle, I mean, I would crave as an academic and as an intellectual, I would be delighted if the parliamentary opposition to China in the United States or the United Kingdom could take the form of detailed legal argument with precise formulations about exactly what is going on that China is doing that they disapprove of. But the language used is very much very, very general, that the high degree of autonomy of Hong Kong has been eroded and that basic rights in Hong Kong have been eroded. This is simply a very common aspect of what I would call, and what Chen would call, bad diplomacy, a decay or a decline of diplomacy. Another general point I would make is that there is a great deal of talk about the nature of a treaty as a legal instrument, though of course that Britain should talk about that at the moment is rather difficult given its attitude to the Northern Ireland Protocol, which it signed with the European Union. And I come from the north of Ireland, so I have a concern about the disregard of this protocol, which is a good deal, very, very precise about the obligations of Britain to respect the north of Ireland remaining within the European Union for customs and trade purposes. But I mean, I think the point has to be made that the registration of the Joint Declaration under the UN Charter really merely provides, it doesn't add to the legal quality of this declaration. That legal quality depends upon the formulation of the terms of the treaty. It merely allows countries to invoke this document in United Nations organs, including the International Court of Justice. But it is a fact, there is, in my view, this is a very academic point, but in my view, there is a misunderstanding, also very widely shared among international lawyers, about the nature of treaties. Treaties are diplomatic instruments. They are an expression of diplomatic relations among countries. They are not contracts for the sale of goods or for the transfer of property. And they are instruments that have to be understood in the diplomatic context of relations among countries. And one must be aware, and there's a very distinguishing English international lawyer called Fawcett, who wrote an article about this in the British Yearbook of International Law, the nature of international treaties. Every international treaty is normally a diplomatic instrument, most of which does not allow itself to be just legally justiciable. It's an expression of sentiments, an expression of mutual regard, an expression of continuing relations among peoples. It's not something which judges can pass as if they were dealing with some private law issue. So there's a far too much expectation loaded onto the notion of a treaty by general public opinion. But this is not to say, and I am not saying, that treaties are not significant, that treaties are not a serious instruments. Treaties are the foundation of mutual respect among peoples, and they are the foundation of good faith in the relations among peoples. But these are not judicially easily justiciable concepts. They require a very special type of treatment, which I think is very much damaged by parliamentary diplomacy of the kind that you get particularly in the British House of Commons at the moment with the Foreign Affairs Committee and so on, and the utterances and outbursts of the Secretary of State Pompey in the United States. So
they are consequential. They produce their consequences. So you have the escalation of war of words, and you have sections, you have countermeasures. So given the decision of the Chinese Foreign Ministry, Chen said was yesterday, do not recognize the British issued passports, then what would be your forecast? What would happen next? I mean, it will go beyond the war of words, right? It will have real consequences.
Is that addressed to me?
Yeah,
Tony.
Yeah.
Tony, did you want to say something?
Well, simply that the original exchange of memoranda in 1984, December 1984, indicated in a spirit of goodwill that while as a matter of principle, China regarded all of the residents of those born in Hong Kong and living in Hong Kong to be Chinese nationals, that, you know, for the sake of good relations with the United Kingdom and with Hong Kong, it was perfectly prepared to allow Hong Kong persons to use British national overseas passports as a method of travel. This was possible in a spirit and atmosphere of goodwill that existed at the time, but with the absence of mutual trust and mutual respect for one another's good faith, it is hardly surprising that this Chinese willingness to, as it were, be very flexible should be disappearing. The solution to that is not some kind of acrimonious arbitration, as Chen has so clearly expressed, but through a restoration of civilized discourse among the participants in this conflict.
I'm fairly cautiously optimistic because I think we can trace these actions and threats of future action to very precise parts of the deal in 1984. The deal was that since we all know that at the time that one of the important issues for the United Kingdom was the prospect of more than 3 million British nationals overseas suddenly making their way for London. In fact, at the time, the important issue was to prevent that from happening. Well, what the People's Republic of China did was to extend its nationality to what it described as Hong Kong compatriots. Now, you might ask, what business does a country have to extend its nationality to a group of people who may or may not welcome that nationality? But the fact of the matter was, had that not been done, in effect, more than 3 million people would have become stateless. And from a Chinese viewpoint, if you look at it, it would be like saying, would you absorb more than 3 million foreign nationals overnight? The answer was to extend nationality to people in Hong Kong Then the question that arose was, what about these British nationals' overseas passports, which can't actually quite get you into England? The PRC said, well, we'll recognize these BNO passports. We won't recognize them as passports, but as travel documents, except for travel into mainland China. Okay, so in other words, you can issue these BNO passports, go ahead and do so. We don't recognize them as passports because a PRC national can only have one passport. But we will make an exception here because we don't treat these BNO passports as passports, but merely travel documents. You can have them. What Britain did as a response to what it claims is a violation of its treaty rights, which China denies, is to say, well, now I'm going to let you use the BNO passport, and starting in January 2021, you're going to have a special kind of visa category that gets you in. The People's Republic of China has said that it considers that to be a breach of the deal done in 1984. So you believe that I violated the treaty. I don't believe I violated the treaty, but because you believe I've violated the treaty, you do this. You say, I'm going to let BNO passport holders come in January 2021 on this special kind of visa category. So in response to that, I think you've violated the deal that I had with you. So for my part, I might consider not letting someone use their BNO passport, as far as I'm concerned, so far as that falls within my control. And where might it fall within one's control? We can only speculate. No doubt you can't use a BNO passport to enter the mainland anyway. The South China Morning Post has gone on to say certain other things, but whether those things will transpire or not, we don't know. For my part, what I see are very precise responses. These responses are classified by international lawyers as forms of what we call retortion. You referred to countermeasures. These are countermeasures that are not in themselves unlawful necessarily, but they are a response to perceived violations of one's international rights. The very fact that it is so carefully calibrated at both ends gives me some cause for cautious optimism. I don't see escalation. I see a situation that is being managed and which is being managed actually quite carefully. So I don't see a sudden irrational escalation on either side.
Okay. You have anything?
I may be wrong, but that's my view of it.
Okay. Right. So there's a question for Cheng Lim. I think you touch on that question. I think it's just ask you for some elaboration, which is a joint declaration has no impact at all after the handover.
Well, from China's point of view, it had a tremendous impact in the sense that Hong Kong was recovered. But beyond that, what you have, not solely but largely, is the first annex, Annex 1. And Annex 1 is called an elaboration of the basic policies of the PRC in relation to the Hong Kong SAR. The United Kingdom thinks that that annex is extremely important. As a matter of international law, there is no doubt that an annex to a treaty is a part and parcel of that treaty. There is no question about that. But that is not the PRC's point. The PRC's point is one of interpretation. It is one of construction. Properly interpreted, do the contents of the annex impose duties of conduct on the People's Republic of China? Or is it merely the People's Republic of China clarifying what its own policies should be? And so I think in response to your question, has it left the United Kingdom with nothing? Certainly not from the United Kingdom's point of view. But it has nothing to do with the question of validity. There was this almost false debate about whether China somehow considers that the treaty is not valid. If I were in the position of the PRC, even though I think that this is a fully executed treaty, there is no harm taking the view, and it may even be advantageous, that the treaty remains valid even though it has been fully executed. That is because the treaty provides the legal basis for what in this case is the recovery of Hong Kong. At the end of the day, it doesn't matter either, because even if the treaty is no more, Chinese sovereignty over Hong Kong facilitated the resumption of Chinese sovereignty over Hong Kong, facilitated by the treaty, is simply an objective fact now.
Thank you. Yeah, Tony.
I would stress as well that the article that was being read out by Albert, the Article 4 of the National Security Law, and I think it's all been mentioned by Chen. This, it seems to me, to be a very firm declaration by China that it intends to continue to observe the guarantees that it offered in the Joint Declaration. And so it seems to me that here is an area, I'm not trying to cause legal trouble here, but here is an area where there can be argument about the meaning of the various rights as a matter of international law. What freedom of assembly, freedom of expression,
yes,
academic freedom, so on, can mean. These are, like everything else in international law and society, highly disputed areas of debate, but they are areas of legal debate. And there are legal fora, including the Human Rights Committee of the Civil and Political Covenant, which applies to Hong Kong and which continues to apply to Hong Kong under the National Security Law. So there is scope here at the level of individual rights and group rights for legal debate and argument. And the National Security Law does not attempt to foreclose this. It reasserts these rights. And China is constantly asserting that the fundamental principle of the base of the Joint Declaration, one country, two systems, should be maintained. And it is the fundamental principle that China is using to shape its policy towards Hong Kong. So I don't see any substantive repudiation of the underlying principles of the Joint Declaration in any of the Chinese public declarations with respect to Hong Kong. In fact, they are probably wary of falling into the trap of appearing to repudiate the fundamental principles of the declaration, the one country, two systems, and the guarantee of the basic rights as a matter of international law of the people of Hong Kong. All of that remains in place. And they are not, China is not allowing itself to be provoked into disregarding these fundamental pillars of Hong Kong.
Well,
can I add some? Sorry, Albert, please carry on.
I agree with what Tony has just said, and I'll supplement by saying that this national security law is primarily going to be litigated and applied by the Hong Kong authorities, Hong Kong courts. So unless and until the mainland's National Security Office in Hong Kong exercises its jurisdiction in those what I consider to be very exceptional circumstances, unless and until that happens, it will be up to Hong Kong courts to interpret and apply the national security law. And as we have seen in the court of first instance decision in the Tong Yin Kit case, the Hong Kong court took very seriously these articles in the NSL, Articles 4 and 5, on the recognition of human rights and the ICCPR and principles of rule of law, presumption of innocence, protection of the rights of accused. So all these principles are expressly mentioned in Articles 4 and 5. And I think Chen Ling discussed earlier on whether these articles don't really matter. But I would suggest that they do matter, because the judges which try the cases on NSL, the judges who interpret and apply the NSL, believe that these articles are important, and they are going to, and they have said that they're going to interpret an NSL in accordance with these principles of protection of human rights, ICCPR, rule of law, protection of the rights of the accused, etc. So that matters a lot, because the law may not be very clear on some issues. It has been criticized to be vague, at least in some of these provisions. But all these matters are going to be resolved at some point, if there are really cases brought under this law by the courts. So the courts will, it seems that there is sufficient material in this law, sufficient instructions written into this law to enable the judges to interpret the law in a way that is consistent with human rights and the rule of law principles. So of course, if the NPCSC issues an interpretation, the courts will be bound by it. But until and unless there is an interpretation, the courts will still be free to interpret and apply the law in accordance with the common law and these guarantees of human rights in the NSL.
Chen Ling, you have the final word.
Thank you. No, what I said, Albert, in relation to Article 4 of the NSL was that I'm heartened by positions such as Lord Reed's position, which is wait and see, which I think essentially is your position as well. But let me just say one thing. I think it is strategically important, just as one might hold Britain to its promises on the part of a segment of the community. It is just as important if the NSL says your rights will be preserved, to hold the NSL to that as well. Because if you say, I don't believe my rights will be upheld, then you give no party any cause to have your rights upheld.
Thank you. Final comments? If not, so now we're reaching the end of the 2-hour discussion. I want to thank our panelists for their wonderful presentation and the questions from the audience. The conversation will continue as long as there are interest out there. I think we're just at the very beginning, as someone just said. Wait and see is the right attitude, probably as a matter of principle and as a matter of a strategy. So thank you, and thank you all, ladies and gentlemen in the audience, for spending the evening with us. I wish you a good weekend, and I'll see you next time.
Thank you.
Goodbye.
Yeah,
Nice
thank you,
to
Tony.
see
Bye.
you.
Bye-bye.
Bye.